I'd like to begin by acknowledging the traditional custodians on whose lands the Australian National University sits, and from whose lands I'm speaking to you today, the Ngunnawal and Ngambri peoples, as well as the traditional custodians of the lands on which each of you live, work and learn. The First Nations people of Australia have had an intimate relationship with this landscape for thousands of years. They have met on country to learn and share knowledge, to talk and to listen, and to discuss ideas and solve problems. And they have used that knowledge and these ideas to care for the country and to practice law thousands of years before the systems of international law that Professor Hathaway will be talking about tonight were developed. As we come together tonight, I'd like to pay my respects to the elders of this country, past and present, and to the culture, knowledge, kinship and connection that they hold in relation to country. My name is Imogen Saunders and I'm the Director of the Centre for International and Public Law here at the ANU College of Law. I'm delighted to welcome you to the Kirby Lecture in International Law to be delivered tonight by Professor James Hathaway. The Centre for International and Public Law has sponsored the Kirby Lecture since 2008, launching the series to recognise and pay tribute to the pioneering international law work of the Honourable Michael Kirby. Justice Kirby cannot be with us here tonight, to his great regret, as he has a prior unavoidable commitment. He sends his apologies and wishes how much he could be here. And I do very much wish to acknowledge him and thank him in his absence for his support of this series, as we gather here for the 16th iteration of this lecture series in his name. The Kirby Lecture has become the foremost public international law lecture in Australia. It has been given previously by luminaries, including Judge of the International Court of Justice James Crawford, Sir Kenneth Keith, Judge Christopher Weeramantry, and of course Australia's current judge on the bench, Judge Hilary Charlesworth, as well as outstanding and leading international law academics. Our speaker tonight, Professor James Hathaway, sits very comfortably in this list of international law superstars and needs very little introduction to most of you in this room, but I will do so briefly anyway. Professor Hathaway is the James E. and Sarah A. Degan Professor of Law at the University of Michigan Law School. He works in the field of public international law with a focus on international human rights law, international queer rights, and international refugee law. And although Professor Hathaway's work encompasses all three of these fields, tonight it's the first two that are the focus of his lecture to us. The topic of Professor Hathaway's lecture is claiming queer liberty, arguing for a right to sexual liberty in international human rights law. This lecture comes at a time when the rights of individuals and the curtailment of those rights are issues across the globe, including in countries which were traditional supporters of the international human rights regime. It is a timely lecture on an important topic, and I ask you to join me in welcoming Professor Hathaway to give the 2024 Kirby Lecture.
Well, thank you very much. I actually wish Imogen hadn't mentioned all of the luminaries who've given the lecture. I now feel like I should crawl under this podium and just go home. But I won't, because I'm really delighted to be back at the ANU. This was one of the last places I spoke before I concluded my deanship at Melbourne Law a decade or so ago. And in that sense, it's a lovely homecoming. This was a campus that was very welcoming to me during my time in Australia, and I found it so again. This is a very special place of which you should all be extraordinarily proud. I'd like to thank Professor Tony Connolly, the Dean, Professor James Stelios, the head of school, for facilitating the invitation to spend 2.5 weeks here at the ANU. Professors Imogen Saunders, Kate Ogg, Leighton MacDonald, who did all of the work of organizing my visit. And I must say also Brenna Barker-Lamb and Kinsard Adeli, who actually made the logistics just super easy. All of this has really made my time here a pleasure. But most particularly, I want to thank the Honourable Michael Kirby, who I am very lucky to count as a friend and in whose honour I speak tonight. His commitment both to international law generally and to the rights of sexual minorities very much provide the inspiration for this talk. And I'm really sincerely honored to speak in a lecture that bears his name. As many of you will know, the Global International Human Rights Project, anchored in the non-binding Universal Declaration of Human Rights, familiar to all of you, I'm sure, is only about 75 years old. In the sweep of international law, this is a baby. The portions of international human rights law that are legally codified are the two covenants, real treaties, not just aspirational statements, as was the Declaration. One, the International Covenant on Civil and Political Rights, that speaks to issues familiar to Western societies like free speech, liberty of movement, rights of religion. And a second, born of the socialist tradition, the International Covenant on Economic, Social, and Cultural Rights, that speaks, for example, to rights to education, to work, to social security. All of these norms have sought to codify what a good life, what a life lived in dignity looks like. And they now bind roughly 3/4 of the states in the world and are enforced by expert oversight, and indeed now an optional individuated petition procedure under each of the treaties. As remarkable an achievement as it is to have this corpus of human rights now sitting effectively on top of states, their definition of a good life, of a life lived in dignity, is, in my view, conspicuously silent on the importance of being able to live a satisfying sex life. Yet if we are honest, which among us would deny that sex is an important part of what makes life satisfying, of what makes us feel complete? It is nonetheless the case that even as these covenants codify things like, for example, a right to rest and leisure or a right to take part in cultural life, they do not establish a right to sexual liberty. Now, some might say that that omission just stems from squeamishness. Talking about sex is awkward at the best of times. But I think that's not right. The historical record suggests that the absence of a right to sexual liberty in international human rights law most likely reflects the priorities of the predominantly heterosexual male group that drafted the covenants. It is a reasonable assumption from the drafting history that their priorities did not extend to the codification of sexual liberty, since the variant of that liberty most of interest to them, access to women to satisfy their sexual desires, was both assumed to be natural and in practical terms was not under threat. Indeed, going a bit more deeply, the establishment of a right to sexual liberty for everyone might have been thought to pose quite a threat to the privileges of heterosexual men, enabling wives to decline sexual demands and empowering sex workers to insist on safety and fairness in their sexual transactions. At least as seriously, I think, liberating sexual minorities to pursue lives natural to them would have amounted to a direct challenge to the sanctity of family forms that have long served most straight men quite well. It is thus not surprising, in my view, that rather than codifying a right to sexual liberty, along with all of the other liberties that might be found in these documents, the drafters of the covenants instead proclaimed the centrality of traditional marriage and the heterosexual family. Sexual minorities were not, of course, the only group whose needs and aspirations were given short shrift in the covenants. But the general commitments of the covenants have been amplified and contextualized for several other critical minorities in a host of specialized treaties that have come into force since the covenants in the mid-70s. For example, a treaty on the rights of racial minorities in the late 1960s, on women in 1981, on children in 1990, on migrant workers in 2003, and on disabled persons in 2008. There has, however, been absolutely no move to establish a new UN treaty that would remedy the omissions of the covenant most critical to sexual minorities, and specifically to protect the right to have queer sex, that is, to have sex outside the marital procreative model. Yet for those of us who do seek to lead queer lives, the right to have sex in the ways most natural to us is central to our sense of dignity, of what makes for a good life. Why should international law continue to treat our aspirations as less worthy than those of other outsiders who have, to at least some extent, now been brought into the tent of international validation and protection? Now, I want to be clear, I am not criticizing the advent of the 5 specialized treaties that you see mentioned on the screen. But my question is, if we can do right by these outsiders, if we can bring them closer to being a part of the circle of power and privilege, even when the projects, in particular the conventions on women and migrant workers, were hugely controversial, if we can do that, knowing that they're politically contentious, then why can we not similarly see that there's an ethical duty to do right by sexual minorities as well? Yet the truth is, the UN's engagement with queer rights has been very slow to emerge and highly partial. The very first mention of queer people was in 1994, and I want you to think about that date, given what I'm about to say. 1994 was the first time that the UN's Commission on Human Rights included men having sex with men as a group disadvantaged in the context of the HIV/AIDS crisis. 1994 being more than a decade after that disease had ravaged the gay male community. It took them that long to even say it out loud. It took another 6 years. We're now to 2000 before the UN Commission on Human Rights even took a stand that the killing of people for having had queer sex was internationally wrongful. I mean, let that soak in for a moment. Yet another decade passes before the Commission issues a report on what are called SOGI, sexual orientation and gender identity protection issues. And I want you to note what they are saying here, sexual orientation and gender identity. The focus was and remains not on sexual activity as a rubric, but rather on identity. The Commission decided to take up 5 issues that they thought were relevant to sexual orientation and gender identity. The first being the issue of violence, torture, criminalization, discrimination, and limits on expression and association. You can see that that list is a small subset of the dozens of rights that are in the covenants. And yet these were the specific 5 that were thought pertinent to be raised in relation to sexual minorities. Critically, the Commission, which was rebranded as the Human Rights Council in 2006, has declared, in contrast to its approach on racial minorities, on women, on children, on migrant workers, on disabled persons, that from a legal point of view, we don't need actually to do very much. In particular, you can see the focus on violence and discrimination as the main threats faced by queer people, in line with the more limited list I just showed you. An odd assertion that there are already standards binding on all United Nations member states that are relevant, when even the covenants only bind 3/4 of the world's states, and those are not the states in which the greatest risks exist. And then the pronouncement in the first and second lines that we don't need to create anything special for sexual minorities. Again, completely unlike the approach to all of the other minorities I've just described. In fairness to the UN, the leading non-governmental engagement with queer rights, the so-called Yogyakarta Principles, defined or drafted by a group of self-defined, quote, distinguished human rights experts, unquote, in 2006, had taken a comparably conservative approach. Analysts have suggested that the unwillingness of even these members of sexual minorities to push for new rights was because there had been a number of failures in domestic courts, particularly the horrific decision of the U.S. Supreme Court in Bowers versus Hardwick that had found that sexual privacy did not protect queer rights. Whatever the reasoning, whatever led to the conservatism of these self-appointed experts, it is clear that the UN loved it, because these principles, which have no legal imprimatur of any kind, we could come up with the ANU principles tonight, and they would have just as much validity as a matter of law. These principles have been invoked, regularly trotted out over the past 20 years to justify a rather unambitious approach. So, yes, the UN could have gone farther, but gay and lesbian activists bought into a conservative paradigm that fed, I think, the conservative instincts of the Commission. The net result is that we've really had advocacy over the last quarter century really only focused on two issues. One is the right to non-discrimination. The other is the right to privacy. And I want to describe what we've achieved under each as a way of setting the stage for why I believe we need to go farther. The first, the right to non-discrimination. Australia played a rather critical part in this development. For those of you who don't know, not only Australia, but I would say in particular the Commonwealth government is owed a lot of thanks. Because in the 1994 case of Toonen, which was brought by a gay man against Tasmania's then prevailing sodomy laws, the Commonwealth had very helpfully not contested the idea that sexual orientation was a prohibited form of other status under the provision on non-discrimination in the Covenant. It didn't push for it, but neither did it push against it. I think Tasmania must have been left feeling that it was left out hanging to dry by the Commonwealth. But for us, that was not unimportant because the committee did buy the view that sexual minorities were protected under Article 26, although very oddly, not on the ground of other status, as both the Commonwealth had conceded and the applicant had argued, but rather that it was a subset of sex. They made this judgment without any explanation, and they've never justified it since. Now, I'm not terribly wild about this approach. Perhaps this is in line with Russ Funk's assertion that gay men are honorable sisters in suffering. But the idea of shoehorning sexual orientation into sex is, in my view, far from ideal. It not only diminishes the distinctiveness of sexual orientation as a form of status in its own right, but as some feminist scholars have observed, it muddies the water about the meaning of sex discrimination. But that's what the Human Rights Committee did, and it stayed in that place. Since Toonen, and I actually went through all of the thousands of concluding observations of the committee to find all of the variants of, I will simply say, a queer understanding of sex that the committee has found to be protected. And if you can see from this list, it's a pretty inclusive list. I don't think anybody else has ever pulled this together before. But I have to say, looking at it, I keep looking. I challenged my students to find something that was missing, and it's pretty hard. It is a very big shopping list that all of these things that you see on the screen have been found to be variants of sex for purposes of protection under the covenant. So what's the problem then, you might ask? This actually looks pretty good. I mean, yes, we come in through the back door of sex rather than being treated as having a status in our own right. Yes, as feminists have said, that does muddy the water about the meanings of sex with downsides for women's rights. But we got there. We at least got through the door. I think there are a few problems with this nonetheless. The first one of relying on non-discrimination, and apologies to the non-lawyers in the room if this becomes heavy sledding, as Canadians would say, just stop me. But it is not the case that every differentiation based on status is unlawful discrimination. Under UN human rights law, if a differentiation is adjudged, quote, objective and reasonable, unquote, it's not discriminatory. Now that's an exception through which you could drive many, many trains. And the history of these words is that they are fudge words that have sometimes been applied with care and sometimes very carelessly. In the queer rights context, I want to mention one particularly tragic example of them, in my view, being applied carelessly. And this is the decision of the UN Human Rights Committee on marriage equality, the case of Jocelyn coming from New Zealand. And bear with me, the legal reasoning is convoluted. It is not easy to explain, but I want you to see it because it exemplifies why this idea of relying on discrimination is so risky. The UN Human Rights Committee said, in a challenge that New Zealand had a duty to provide access to marriage for same-sex couples, they found that it was not discriminatory to fail to do so. Again, bear with me. They found it because it was not a breach of a right to privacy, and it was not a breach of the right to privacy because it was not a breach of the right of men and women of marriageable age to marry. I have no idea what the connection is between the two, but that's where they went. The language in the covenant, if you look at it on the screen, protecting the right of men and women of marriageable age, could very easily have been interpreted to mean it's not a right of minors, it's a right of adults. Instead, they decided that self-evidently it meant a man and a woman, and hence it could not possibly be used for opposite-sex couples. And it gets even worse. They decided that it's not a breach of the privacy right in Article 23, and because it didn't breach privacy, they didn't even bother, they didn't feel the need to ask whether it was nonetheless discriminatory. They simply found for New Zealand. That's the kind of intellectual sloppiness that the non-discrimination paradigm lends itself to, because they did not even feel the need to say why something that wasn't a breach of privacy could not nonetheless be discriminatory. And obviously it can't. These are not the same thing. So perhaps you can see from this example on perhaps the most high-profile queer case that has come before the UN Human Rights Committee why I'm not so thrilled to entrust them through non-discrimination with getting my rights right. A second concern with reliance on non-discrimination is that non-discrimination is a correlative right. Persons within a protected category, which now do include sexual minorities as sex, may not be denied access to whatever right is extended to people outside that category. But for non-discrimination to work in international law, queer people, even if protected on the grounds of their sex, must point to some entitlement granted to other people, but withheld from them. The problem is that if the matter of interest is not guaranteed in the catalog, queer people have no greater access to it than anyone else. That may sound fair. Why should queer people get better rights? But it actually isn't fair. This is because straight people benefit from an unquestioned, if still uncodified, right to engage in mainstream marital procreative sex. In contrast, queer sex benefits from no such presumptive entitlement. With no underlying right to sexual liberty to which non-discrimination can attach, queer people are in a very vulnerable position. A third concern with the non-discrimination framework, particularly voiced by critics from the global South, is that it buys into an identitarian legal framework. All of these forms of identity presume that the applicant is disfranchised in some sense because of who she is, right? These are all forms of identity. That's what non-discrimination is about. If queer people do, in fact, identify with any of these groups, that's not a problem. But for other persons who seek simply to engage in forms of sex that transgress social norms, the idea that the only way to get protection is by asserting some kind of group identity may seem quite foreign, if not downright off-putting. Whether because they choose to live on the down low or otherwise have no desire to disrupt their traditional family, matrimonial, or other structures, a significant number of persons, especially but not only in the global South, wish to have queer sex without belonging to any queer community. Ratna Kapoor writes, "The gaining of queer selfhood through visibility may involve great losses. This is not a no-cost proposition. Family, social rejection, ostracism, being deprived of home, livelihood services, discrimination, humiliation, all of this would be the cost of identifying as queer in many societies. And to ask people to pay one of those prices in order not to be discriminated against seems extraordinarily punitive." As Matthew Waits has written, the challenge is to protect people not for who they are, but for what they do. And that's where we have thus far failed. The fourth concern, and you'll be relieved is the final concern, about non-discrimination. I usually stop at 3. As a lapsed Catholic, there's a certain beauty with always ending in 3. But this one there really are 4. The fourth concern, even assuming that non-discrimination law protects people having queer sex against most negative consequences, violence, imprisonment, whatever, that come from living their authentic sex lives, this really is a backdoor route to validating our dignity. And I want you to think about this for a moment. Imagine if there were absolutely no right to freedom of religion, but we said to a Jew who was tortured for going to synagogue, or to a Muslim who was beaten for saying his prayers, that the consequential abuse would be found wrongful, even if the thing, the praying, was thought not worthy of being protected in and of itself. Would we feel good about that? I think not. Or what about a world in which there was no right to freedom of speech or freedom of association? But if somebody shared their political views and was thrown in jail, we would say that was illegal, even if they had no protected right to speak in the first place. Surely we would not accept that approach to liberty of belief or expression. And that is because, as critically important as the consequentialist protection is, and it is important, the central purpose of human rights law is explicitly to name and to protect that which is fundamental to human dignity. People who seek to lead non-traditional sex lives, in my view, deserve no less. And so, in sum, the non-discrimination framework is, I think, problematic because of this highly subjective, reasonable, and objective differentiation standard. There isn't an underlying right to sexual liberty to which non-discrimination as a correlative right can attach. The identitarian focus is at odds with the self-perception and the lived reality of many people in the world who have queer sex. And finally, the consequentialist nature of protection through non-discrimination doesn't do the basic job of human rights law, which is to name and to protect that which is most central to our sense of dignity. This then brings us to the second option that we have open to us, which is the right to privacy, codified in Article 17 of the International Covenant on Civil and Political Rights. And again, I want to acknowledge that this right has at times been quite useful. It has, for example, been used to argue for the decriminalization of same-sex conduct. It's also been drawn upon to question a few other practices, prosecutions for public indecency, for, quote, imitating members of the opposite sex, unquote, and for propositioning a person of the same sex. But in all of the years since Tunin, not once, whether in a concluding observation or in a case, not once has the UN Human Rights Committee ever said that the right to privacy requires full respect for sexual liberty as an inherent part of privacy. And of course, remember, in the same-sex marriage case, Jocelyn, privacy was rejected as a legal basis to strike down the exclusion of same-sex couples. International privacy law has also been invoked to legitimize some quite harsh measures against the most marginalized parts of the queer community. More queer people around the world are jailed, abused, and tortured under laws that target sex work than are arrested under sodomy laws. These include not just queer sex workers, but other people arrested for loitering, cruising, or, as the famous phrase goes, walking while trans. As Professor Di Otto has said, while some former deviants have been welcomed into the charmed circle of good sexuality, the demonization of those who remain on the outer limit has actually gotten worse. But beyond those points, there is something just conceptually very, very odd about invoking a right to privacy in order to secure sexual liberty. If liberty means anything, surely it means the right to be and to act in the ways natural to oneself, not in private space, whether in private or not. For many queer people, the goal is decidedly not to do what one wishes only in the privacy of one's own proverbial bedroom. As the ANU's own Wayne Morgan has argued, doesn't reliance on privacy actually silence sexual differences rather than validating it? And I think that is exactly right. Indeed, most queer people want to be able to express themselves as freely as heterosexuals do in public spaces, whether that be by holding hands, enjoying an embrace or a kiss, or even by finding a nook in a park for something more sexually robust. It's simply true that many people, queer or not, take pleasure in romantic intimacy in places not purely within the private sphere. Reliance on privacy to vindicate sexual liberty, moreover, assumes access to a private space for such sexual and romantic connections, an assumption that is just not realistic for many people whose economic or social circumstances require them to share housing with others. That concern is especially acute for people seeking to have queer sex in poorer countries, precisely the same people who are most frequently failed by non-discrimination law. They get it coming and going under both of the dominant routes. Even for queer people in the global South who might want to have queer community and identity, the things that are protected, the economic and social conditions that allowed queer communities to blossom in richer countries have yet to arrive in many parts of the world. As Mark Gevisser so eloquently put it, in most poor countries, there is simply no space to be gay. So in my view, reliance on privacy law to vindicate sexual liberty is, like reliance on non-discrimination law, problematic in several respects. And now I can revert to my customary three. First, it's a highly selective application to date for those whose lives most mirror heterosexual forms of sexuality. It is conceptually odd to invoke privacy to protect something that is typically public when it's problematic. And it assumes access to a private space that does not fit with the lived reality of so many poor queer people. Again, my critique of the reliance on non-discrimination and privacy is not meant to take away or to devalue the good that we have achieved under each of those rubrics. For many queer people, these have been monstrous gains. The rapid shift in international human rights law, again, if you remember from 30 years ago, not being able even to mention gay men as being decimated by AIDS. The shift from that moment to a present moment in which, for example, the shutting down of queer free speech and association is routinely criticized under international human rights law, is extraordinary and important. But I do think that our future agenda needs not to rest on the laurels of what has been achieved. And that is, I fear, exactly what is happening. Queer advocates and the UN human rights machinery have, I think, become complacent. It's a little bit like that horrible picture, if you can remember, from 2001 with George W. Bush standing on an aircraft carrier saying, "Job done," right? Yeah, not so much. And in this case, we are in the same scenario. We can celebrate what we've achieved without failing to recognize that we've left a fair number of people, again, predominantly in poorer countries, out of the paradigms that we've thus far been able to use. I want to be clear that what I'm not arguing for. I'm not arguing for what Ratna Kapoor has called unfettered sexual freedom. I'm actually making a much more limited plea that we treat sexual liberty like we do all other liberties under international human rights law. I've put on the screen the text for the right of peaceful assembly, which you can see is not absolute. It can be limited if the restrictions are demonstrably necessary in a democratic society, and those are big words that have been deeply interpreted to make sure that it's not an excuse for some kind of perverse or particular interpretation. If they're necessary, in other words, there is no less intrusive way to do this than restricting these rights in certain protected interests. And I would suggest that sexual liberty follow that pattern. This creates what international human rights lawyers call a dialogue of justification. And you may say that that doesn't sound like much, but it totally would shift the dynamic. The onus now is entirely on the individual who wishes to enjoy sexual liberty. This would flip the paradigm. The presumption would be that sexual liberty is protected, and the duty would then fall to the state, adjudicated by the UN Human Rights Committee, to show that it was demonstrably necessary, no less intrusive means to achieve one of these critical ends in a democratic society. And I think that shift of onus would be a huge deal. It would literally reverse the situation in which we find ourselves now, but not doing so in a way that is revolutionary because it follows the pattern of every other liberty that we've already codified. Nor do I think that the project is politically impossible, as the promise of a comprehensive right to sexual liberty, I think, actually has a number of allies. It holds promise for other sexually subordinated subjects, logically, as Professor Brenda Cosman has said, including most women. The idea of gender outlaws is, in her view, and I agree with this, a political ally of enlightened feminism, struggling against the very same restrictions on the performance of gender within a heterosexual matrix. So whereas perhaps the first generation of feminists would not have found this compelling, I think that the modern feminists understand that sexual liberty is part and parcel of an understanding of feminist liberty. I also think it's the case that the project is more and more likely to be supported by, quote, straight people, both women and men, whose preferred sex lives are not protected by the relegation of sexual liberty to just a subset of privacy. As people increasingly embrace more inclusive and fluid understandings of sexuality, the appeal of a broadly framed right to sexual liberty, I think, is only likely to increase. And somewhat more controversially, and I raised this one with a little bit of trepidation, but I think it's important to see, it has even been argued by some Muslim scholars of international human rights law that this might diffuse some of the antagonism traditionally voiced by Muslim governments to queer rights framed as identity. And his point, as you can see on the screen, is that when it's framed as identity, that's used as a cudgel in what he calls a homo-nationalist fashion to criticize, demean, and belittle states that don't agree. Because the non-discrimination suggests that countries are backward if they fail to protect queer people against discrimination. The argument is if we instead talk more about protecting people's right to live and to act in ways natural to them, there are actually quite rich traditions of same-sex activity in many Muslim and other non-Western societies. Traditions that bespeak indigenous understandings of self-actualization and sexuality, but which do not align with the Western identity-based approach, which is what we have had to date. But the bottom line, to be truthful, is that even if advocacy for sexual liberty were not to bring on board those who now embrace sexual fluidity, even if it were not to bring on board the progressive feminists, even if it were not to bring on board the open-minded Muslims, as theorists suggest all three should be the case, even if that were not true, I still think it's the right thing to do. As Joseph Massad has argued, it is not the gay international or its upper-class supporters who will be persecuted, but rather the poor and non-urban men who practice same-sex conduct and who do not necessarily identify as homosexual or gay. That's the group with which I think we need to speak in solidarity. So a full-throated right to sexual liberty is about proclaiming sexual choice and divergence as positive things, in the same way that we say that diversity engendered by freedom of belief or freedom of speech or freedom of work choice are positive things. Sexual liberty should, in my view, be protected because it is a big part of what makes life worth living, because it enables us to connect and to experience pleasure and emotion in ways that are natural and important. A right to sexual liberty shifts the discussion away from the culturally cribbed assumption that the choice of sexual partners or activity necessarily implicates one's identity, allowing sex to be understood instead as something worthy of protection because it has value in and of itself. I think this vision fits completely easily within the classic liberal framework of international human rights law. This is not a radical project. As Martha Nussbaum has written, what we must do, liberal principles themselves demand more than non-discrimination and privacy. True equal respect requires the capacity, she says, for imaginative and emotional participation in the lives of others. That's what real good liberalism looks like. And so I want to conclude with a quote from a classic liberal. John Stuart Mill, how do you get more classic than that? To show that this is not a radical project. It fits easily within the classic liberal paradigm for reasons that Mill has stated in On Liberty. In this age, he wrote, the mere example of nonconformity, the mere refusal to bend the knee to custom, is itself a service. Precisely because the tyranny of opinion is such as to make eccentricity a reproach, it is desirable in order to break through tyranny, boy, is this timely, that people should be eccentric. Eccentricity has always abounded when and where strength of character has abounded. And the amount of eccentricity in a society has generally been proportional to the amount of genius, mental vigor, and moral courage which it contained. That so few now dare to be eccentric marks the chief danger of our time. Thank you for listening.
Concept that gets spoken about in tort law called sexual exceptionalism, where some offences are treated as different because they're sexual in nature. Do you see how the UN treats sex and queer sex specifically as kind of an extension of that?
God, that's really interesting. I mean, I haven't thought about tort law since 1975. And I had a tort law professor who believed there were only intentional torts. He didn't teach any negligence. So I'm probably the least qualified person in this room to answer your question. But is the idea that sort of carving out a niche for things that have a, quote, sexual element is in and of itself discriminatory? Or what would your reaction be when you were thinking the question through?
Also, the law has a tendency to treat anything sexual as exceptional and therefore deviant.
Yeah, and this goes back to the point that, you know, as the good feminist scholars have said, the reason we didn't talk about this in the drafting of any of this is because the predominantly straight men who drafted it didn't see it as a problem. And they certainly didn't want to be liberating the people that they wanted to have sex with. So I think there is a history of this. I'd like to think that in 2024 we're moving past this. I know that's slightly optimistic, but I said moving, not have moved. And so I like your question. It's another indication of the exceptionalism of sex and why we have such a hard time seeing, as I think a classic liberal paradigm does, that everything that liberates human potential that doesn't hurt other people is to be prized. Yeah, that would be a lovely place to end up. Somebody from the middle section, please.
The example that you provided in terms of the number of different ways that sex, gender, and sexuality are described.
Yep.
Clearly, it's a challenge for international law to define the queer community more generally.
Yep.
To what extent do you think that queer people generally, and you may or may not be able to answer this, are involved in the drafting, even today, of any of the decisions when you refer to the complacency level that exists?
Yep.
Often I personally found that complacency exists and a lack of nuance exists where there are not queer people present.
Yep. And I would go a step farther, and this will be even more controversial. I think that sometimes those who purport to speak on behalf of queer communities may not, in fact, be speaking on behalf of the entirety of that community. I mean, this is the classic idea around the right to marriage debate, and there's been much written about this, as I'm sure you're aware, but that these were largely concerns of upper middle class white gay men who wanted to be married and live like their straight friends. Many poor queer people thought that not being fired from their job actually mattered more. But those voices did not make it to the top of the totem pole. And when I referred to those who gathered to devise the Yogyakarta principles, and they called themselves, they at least were honest, self-appointed experts. I mean, who were they? They were not elected by anyone. They were oftentimes people who had fairly traditional understandings of human rights and who simply transposed that into a comfortable framework for where they were coming from. So what people like Ratna Kapoor and others have, I think, really been helpful in showing us is the complete lack of global inclusivity in the design of this regime. I mean, her point that people in the global south would have started with the ability to have a sex life first, long before getting married right? Then we didn't do that because we didn't feel under threat for that. And so the we was an artificially truncated version of queer community in ways that I think we now need to remedy. Again, I'm not angry at the fact that they took the low-hanging fruit, the easy things that's fine. And strategic arguments might be that that was wise. But we've done that. And what is not legitimate, in my view, is to rest on our laurels. If we believe that human dignity is something of value to everyone, not just the ones who live near us and who live like us, then we need to rethink our strategy.
Noting the diversity that exists within the LGBTIQA+ community generally, and the progression that we've had in LG and B,
Yep.
I think it's well established, comparative to TI and A+. To what extent do you see that agenda continuing to move forward while the LG and B agenda moving forward and potentially bringing along the minority within the minority?
Yeah, and so there are some parts of the world that have done better than others. And I would say, probably, in my view, the most inclusive understanding is that's been adopted by the Inter-American Court of Human Rights, that is actually pushed in exactly the direction you just described. Much broader than the European Court of Human Rights, for example. So again, an example that maybe not everyone in the classic Western system has the most inclusive thinking, and there are ways of pushing it forward in a holistic way. I guess my point is that the focus on being rather than the focus on doing is necessarily partial, to put it really simplistically. In the same way that it's right to protect someone for being a Jew or a Christian or a Muslim, but it's also important to protect the right of everyone to pray or to hold beliefs, not just to be something. And there's no reason we can't do both that I can see.
You just referred there to strategic reasons, and I wondered on the historic record and whether you'd need to do interviews to find out, were there elements at the UN, for example, who were saying, you know what, we've got this international human rights law does cover sexuality, so all of those people who want to deny, you'll just have to live with the fact that it is already covered. Was there an element?
Yes. And some of those people were involved in the Yogyakarta Principles. There were people who were involved with the UN Commission process who were part of that group. So, maybe it was unfair to refer to that as taking the low-hanging fruit. But it may not have been an irrational decision at that moment. And I really want to insist on this. I'm not criticizing. I'm grateful that queer people have the right to pursue things that one might think heteronormative. There's no reason not to have the right to have children and families, and of course. But I do think it's important that we not leave behind those who have more difficult lives and who are seeking something more basic that we have yet to talk about. That's all. Yes, please. Oh my God. We go from a hard question to the master of Australian law on this subject. Yes, Wayne.
Not at all, although I am tempted to take you on a little bit about your optimism. And I suppose that's where my...
This is good, because then I seem reasonable at the end. Go ahead.
That's where my question goes. So, and of course, I don't need to tell you the way in which queer rights are under attack globally.
Yep.
Not least in North America. And I'm wondering too, when I think about what you're arguing, and of course on paper I completely agree with you and have argued similar things myself, but how would you see practically, in the age that we're in, this right being established? All of the other rights you talk about and the liberties, the freedoms, are in the documents, right?
Well, except for the new treaties on women and kids and all the other groups that I talked about. They were not, right?
To begin with, no.
Right.
But then don't we fall into the same problem that we have with establishing a treaty based around sexual minorities in the first place?
Yep.
So, either the right to sexual liberty has to be written into documents,
Yep.
and I find it difficult
To imagine it.
to imagine how that's going to take place, or else it has to be derived
From something that's already there.
from something that's already there, and then we're back into exactly the same problems with privacy, non-discrimination
Yep.
that you have already identified. So
It's a really great point. And you would almost think that if it were to go anywhere, I would have put it under freedom of expression as opposed to privacy. It comes closer, I think, to a place where one could do the interpretive exercise that you're now describing. I guess, can I put back to you the question, which is, if we assume that modern feminists, that sexually fluid people, and at least the conversant Muslim community that wants to engage this are natural allies, is that, in your view, a sufficient constituency to actually raise the issue without without prejudging the form it takes? I'm less worried about whether this is, a protocol 2 or a new treaty on, or as I think you're suggesting, a dispositive interpretation of an extant right. I mean, if we get there in a way that is solid and reliable, I'm not a big formalist. But are those three constituencies, do you think, capable of mustering enough power for the queer community to have natural allies and make this happen?
I see great potential in those coalitions.
Yeah.
I'm not perhaps convinced that, it would be enough to achieve those goals within then forums like UN forums. And I see you and I have talked about this separately, I see other bases of coalition that perhaps are broader still and may have more potential. As you know, one concern I have about a right to sexual liberty is that it perhaps does not bring in questions of gender identity and the gender diverse community in the same ways as other bases for coalition might. But I suppose I'm just not quite as optimistic.
I get that.
Even on the basis of this.
So I guess, part of my answer to your latter point is, and you and I have also talked about this, I think gender identity actually is on very solid ground within international human rights law right now as a protected form of discrimination, a prohibited form of discrimination. I'm less worried about it because it's actually easier. It's an identity. I mean, to the extent we have problems, it's around the definition, again, as you and I have discussed, some jurisdictions saying, it's only post-operative transsexuals who actually are of the status. Others say that's ridiculous, and of course we ought not to. And I think there are ways to argue that issue without undermining the fact that trans identity is identity, which I don't think we want to lose. I think we want to hang on to that, and that can be one. I guess, where I've ended up, and the reason I asked you the question is it was an honest question, because my own view is that even if we do not win the battle, not showing solidarity with people whose sex lives put them at daily risk in situations that those of us in this room can't even imagine, it's just ethically wrong. And I would actually even if I lost this battle, I would feel better for having tried to make it happen, because not to do that is really to be, I think, extraordinarily othering about the majority of queer people in the world, who are not sitting around thinking about where they're going to buy their wedding ring. They're thinking about things that are much more visceral. Like, can I actually have a sex life and survive economically? So I guess I felt some solace that there were at least those three other communities that I think are allies, that are voices that have some stake in sexual liberty as a broad concept. And I think we ought to push for it, even if in the end we fail. But I would also be happy if we ended up with that dispositive, interpretive, of freedom, for example, of association, that actually included the right to sexual association. There are lots, and I'm sure you've got other ideas. There are 3 or 4 ideas, but the point is we're not even talking about this right now as queer advocates. We kind of like, again, the George Bush analogy. We've done it. We've won. And that's what breaks my heart.
Great.
So I'll start by saying I'm not a lawyer. I have no background in law.
So you're going to ask the hardest question of all then. This always happens.
but it has been very easy to follow as someone who doesn't know anything about law, so thank you for that.
Sure, thank you.
So the other half of the queer people in this world you're talking about, they're living in poorer countries. These countries are less likely to be democratic, less likely to have a robust rule of law,
Yep.
and they're less likely to have access to any kind of legal services. Do you think that even if your proposition went ahead, even if we have right to sexual practice rather than sexual identity,
Yep.
that international law could fix this problem, where in places where international human rights treaties which have been signed may not even be properly implemented?
Yeah, all of that is possible, but let's start with the fact that the two covenants have been signed by 3/4 of the world. Even the Women's Convention, which was hugely controversial, I think I'm right on this, is now all but 7 countries in the world are a party to it. That's extraordinary. No one would have imagined this. Your question then is, so what? It's a pretty piece of paper out there.
So what? It says...
Yeah, I was caricaturing you. Yeah. So 2 things happen. I mean, under the treaties themselves, right, there is at the very least a periodic scrutiny process where the UN committees hold the government representatives accountable in the glare of the public spotlight. And you will be shocked at how many government officials worry about this. The idea of being made to look stupid or backward is very difficult, even for some governments that you might not see as progressive. It's an extraordinary thing to watch, but it does actually work. Some of the treaties also, it's amazing, some countries that you would not think it actually allow their citizens to make direct complaints to these bodies. Some that you think might do it, well, maybe you wouldn't. I was going to say the United States don't, right? But here's my real pitch, is that I think international law is a tool in the hands of domestic judiciaries that do have power. And most of the civil law world, which is the majority of the world, international law is directly applicable and enforceable by domestic judges with the same authority as domestic law. And they have often made incredibly courageous decisions. My main area of work is refugee law, where judges in places like India that haven't even signed the treaty have taken international norms and fashioned them into domestic remedies that the government did not want. So I am a big believer, again, I don't want to sound like the Pollyanna. I know it's not perfect, but something is better than nothing. And some victories are better than no victories. And so when you say, will it fix it? I think the answer is absolutely not. Will it provide us with some victories? And will it make some people's lives better? I think yes. And the transnational judicial conversation of judges empowered by international law is really not to be underestimated. I don't think UN bodies are going to change the world, is my point. But I think domestic judges who have real power and the ability to compel compliance in a way that the UN does not are more and more using international human rights law to generate results that I find positive in other fields. And I think they could do it here, if we don't phrase it in a way that is culturally offensive. And that's the problem. When it's all identity-based and when they are stigmatized as backward for not honoring that in ways that we could avoid by simply saying, as some really brilliant scholars have done, dredging out the traditions of same-sex and other non-mainstream sexual attraction as part and parcel of the cultural fabric of those places. Right? If we draw on that broader understanding of conduct rather than identity, I think we are more likely to get to a positive space.
You know, I can't remember which of the ICCPR you put up, and it showed the exception, and one of them was about
on assembly.
The protection of public morality.
Right.
And I'm just interested in the part, it's sort of a bit about the doable.
Yep.
How you separate out the prurient morality argument from, you know, the obvious truth that you've given us.
I didn't even plant this question, but it's such a great question, because this is one of the areas where the UN Human Rights Committee has actually seen the problem and addressed it. So they have said that morality cannot be based on any one tradition or any one society's understanding of morality. It has to be a pluralist concept that has resonance across states, or else it's invalid for purposes of international law. That has cut down all of these morality defenses to near nothing in cases over the last decade. So I think that's the way we do it. And we give the domestic judges that same tool and hope that they have the good sense to implement it. But you're right. I mean, as written, I mean, this was really unfair. If this were a course in international human rights law, you know, we'd spend a session on each one of those exceptions. There is lots of case law on each of these things, as well as concluding observations and general comments that give us what they really mean. And I think if we drill down, a lot of the risks that I agree with you textually are sitting there are not there once the interpretive process has been taken into account. Thank God. 25 years ago, morality was this gaping hole in about half a dozen rights. And the committee saw that. And to their credit, they took it on. And states have acquiesced in this. So
that's, if I can just,
yeah.
It was more from the sort of stuff that doesn't get spoken about, and you know where I'm coming from, the pragmatics of getting states to do anything in this. Politically, what does it mean for them in terms of their, often the mantle that they like to put on their shoulders about being the protector of morals?
Yep.
Which is quite different, you know, from what you're talking about.
Right.
When you're looking at the law.
Yep.
I'm more looking at, is that going to be the thing, the unspoken thing that makes your task of getting states to actually agree to do anything?
It may be, right? And as you and I have both lived through on multiple occasions, you know, good principles do not always become good law. And there are 101 reasons that that happens that are way beyond our conversation tonight. But I think in my view, again, it kind of goes back to this idea of the importance of the battle. If we actually define ourselves, as I think societies like Australia do, Tampa and its progeny notwithstanding, as rights regarding, as countries that actually do believe that human dignity has transcendental importance, we have to engage that struggle. And I do think, again, if you look at areas like women's rights, kids' rights, refugee rights, it's actually shocking how frequently this international work is picked up by domestic judges who have real power. Power that may trump the political voices that would prefer to go in a different... God, I can't even use that word, can I? Yeah, this is so hard. You know, as an expatriate Canadian living in the U.S., it's like, is it time to move? But I think we shouldn't underestimate the ability of both tribunal members and judges that have authority to wield it in a way that's rights regarding, despite the political imperative of political bodies to go for the lowest common denominator. It won't always happen. Yeah, exactly. And if we give up, then you know, like, what's left, right? I mean, this I think is, you know, a call for us, again, to recognize that an incredibly powerful project has more potential to do more good for more people. And should we not at least make the arguments? Should we not at least explain why this makes sense? And that's really all that I'm calling for. Because this is not a discussion that is happening now. I really want you to know this. It is dead silence out there about this. There used to be something, Wayne, you can help me with this, called the Sexual Rights Initiative, that was the only NGO that I've ever seen that actually made a similar, and it's just disappeared over the last decade. So I'm just inviting us to see what liberalism, which does infuse this body of law, actually compels. And to be truthful to our, again, I have to be careful about talking about liberalism. Small L liberalism actually requires of us is to engage when we think it's right, despite the political winds that may be blowing. Yeah.
What you were saying about sort of, I guess, heterosexual men maybe being threatened by ideas of sexual liberty being enshrined in international human rights instruments. And I suppose I was just sitting here wondering if that may still be the case. And especially if the rights are sort of extended to marrying women.
Yep.
Men might threaten suppose, laws that sort of directly or indirectly punish sex outside of marriage, for example.
Yep.
If you might go up without us. It's sort of,
Well, but I guess what I'd say is, again, the world has changed since then, right? The Convention on the Elimination of Discrimination Against Women, again, ratified by all but 7 countries in the world, has really pushed that ball forward dramatically, but it's specifically discrimination against women. It's not even sex or gender discrimination. It's only against women. So what I'm really suggesting, I actually think that women now have protection in the way that you're worried about that they clearly did not have at the time the covenants were drafted, right? Because a lot of really powerful activists pushed for this treaty, and the committee that monitors it, appointed by states, by the way, they're all appointed by governments. So it's not as though this is some illegitimate, NGO pontificating. These are the experts that governments have given the power to interpret an international treaty, and they've done marvelous things with the CEDAW, the Women's Convention, in ways that, including on, finally they were kicking and screaming on trans rights, but they finally come around, and I think are actually a source of good now. So, I think we can rely on women in ways that we mightn't have been able to when they were equally disfranchised, because now women are in a relative position of power compared to sexual minorities.
Fairly quick one. So I know that the last convention was signed in 2008. Since then, the internet especially has expanded. And for communities like the queer community where people are able to express themselves across online forums,
Yeah.
do you think that the international community is able or appropriately adapted to also express protections for those online forms of expression, not just...
I do actually, and I think freedom of expression has actually been one of the stronger points of the Human Rights Committee's work. And you saw that was even in the 5 that they agreed to do like 25 years ago for queer people. I'm not trying to, again, say they've understood every nuance of the digital age and modern forms of communication, but it's really interesting to read their work, that they have tried to transpose the ideas of freedom of speech to an environment that nobody would have thought about in 1976. So I'm a believer in constant reinterpretation. It's the way we keep treaties alive. And just as we were talking about a victory for women, I think it is possible to have other victories. Not perfect victories, to go back to the will it, fix it, but victories that make life better for more people. And if we aspire to that, I think there is a good chance. Again, thank you for your kindness in coming out tonight, and thank you for your attention.
Thank you very much, Jim, both for your exceptional lecture and in giving a masterclass in answering questions. But I want to invite up one of our alumni at the law school, George Valance, who graduated with us in 2013 with the LLB Honours and a Bachelor of Asia Pacific Studies, who'll give a more formal vote of thanks to conclude the proceedings.
Yuma, everyone. My name's George Valance, and when I was asked to do the vote of thanks tonight, it gave me pause to reflect on the fact that as an ANU community and Canberra community more generally, we're very fortunate here to have the opportunity to have excellent educational opportunities and also to have access to speakers such as yourself, Professor Hathaway. Professor Hathaway's lecture provides us with a timely reminder that despite progress being made, significant legal barriers remain for queer people across the world, including in Australia. In the ACT, while we've seen LGBTIQA legislative reform, and regulatory social reform, and most recently through legislative banning of conversion therapy and the introduction of deferrable medical intervention for people with variations of sex characteristics, there is so much still to be done. Only in the last month has New South Wales taken away the requirements for medical evidence to allow for transgender transition. It's current and it's challenging, and we all have a part to play. Particularly in light of recent international events, which everyone's extremely aware of, I'm sure. It remains of critical importance that each and every one of us as individuals and as our as part of our communities, continue conversations, advocate strongly, demonstrate allyship, and share information to allow us to continue to strive towards an inclusive reality. On a personal note, I am happy to share that this year my wife and I have collaborated with the ANU Law School to create the Valence Family Law Bursary that's available to LGBTIQA identifying students studying a domestic Bachelor of Laws and a Juris Doctors. The bursary is aimed at providing financial support to LGBTIQA law students experiencing hardship. It's important to be visible, it's important to support, and it's important to show up. As proud queers and ANU alumni, Celeste and I both feel very strongly that we have an obligation to use our privilege to provide support and give back where we can. I would encourage you, each of you, to consider how financially or non-financially you may be able to do the same. To conclude the evening, and on behalf of the ANU alumni community and attendees, I speak for you all, tonight I'd like to thank Professor Hathaway. I'd also like to thank the College of Law, which is supporting Professor Hathaway as a distinguished visitor, especially the Dean, Tony Connolly, and the Head of School, James Stelios. I'd like to thank Imogen for her fantastic opening, and also the Centre for International and Public Law, which runs this lecture series. If I could please invite you all to thank Professor Hathaway again. Thank you.